Adam Solicitors on the weekly legal show, and the just a few numbers then. So it's 87.7 FM. If you want to text or WhatsApp, it's 07748 855 055. You can listen online on www.ramadan, that's RAMADAN.FM, or you can call on 0116 482 2086. So we've had a number of sessions before, 3 sessions talking about various aspects of law, and one of the sessions was on debt collection, how to start court cases. We talked about trademarks. We then talked about family and divorce, and then one of the first sessions with Ibrahim Kadri was on property matters. Today I've been asked to highlight 2 matters. One is employment law and one is on consumer rights. So in terms of employment law, there's a number of different aspects that we can talk about. There's a common issue that often arises, which is wearing a religious uniform, or the jabba, or for ladies their dress also, and sometimes there's issues of what is said to be discrimination, and I'll deal with that in a moment. I'll then deal generally with the situation regarding unfair dismissal and how claims are brought, and then I'll talk about discrimination generally in terms of sex discrimination, age discrimination, and disability discrimination and other aspects. So if I deal with one of the common issues that arises, which is a dress code. Now, in certain environments, dress code is important. It's the appearance of the company. It's expected that this is the way you dress in a certain area. For example, in the police force, and they've no doubt adapted, there needs to be a uniform, there needs to be a helmet, and particularly in the Sikh community, it's an issue that often arises, which is someone has to potentially compromise their face because of certain headgear, and they've got around it by compromising. Now, in the workplace, for example, let's take a legal environment. It is expected, certainly, that when you're in court, and court can now mean a public appearance at court, or it can mean a video hearing that you're wearing for a male, a suit and a tie and a shirt. So that's expected attire. If you're a barrister, then there's a different type of attire as well. So that's an interesting question, in that if somebody wants to decide they want to wear, for example, a jabba, or for ladies the headgear and things like that, whether that could potentially cause an issue. So the employer is entitled to take a line, a justified line, of course, in terms of appropriate dress code. So if you're attending a court hearing, then it's expected that you're going to be wearing a business uniform. And in those circumstances, it may be permissible to be able to say that you can't wear an abaya or a jabba in terms of a court hearing or a video hearing. And equally, in terms of client meetings, equally it can be said that it should be formal business wear or smart casual wear. Obviously, a lot of companies have a dress down day on a Friday, and that's fine. It helps to relax, saves time in the morning, etc., getting ready. But that generally is the position on a dress code. Let's talk about religious discrimination. So what if somebody says, well, in order for me to practice my faith, I need to do X, Y, and Z. Now, for example, you've got to ask yourself, is it stopping you from practicing your faith if you are wearing a shirt and trousers? No, it isn't. Obviously, employers need to be flexible, that if it doesn't make a difference, then let people wear what they want. Sometimes, as long as it's smart and it's casual, then there should be no issues. But what if someone comes along and says, well, I'm a health and safety inspector, I can't wear my jubba, for example, because it's said that the length of the item being down to my ankles is actually a danger. I need to tuck them into some workwear, boots, etc. Now, this is a particular characteristic in that an employer is entitled to say, for health and safety reasons, for business reasons, it is necessary to wear a particular type of workwear. And accordingly, that's the position as far as that goes. If you're on a site, you're a health and safety inspector, you're a supervisor on a construction site, you need to go up and down ladders or scaffold or things like that. Obviously, to wear something that it's flowing, trailing, that is quite long is actually quite dangerous, and an employer is entitled to say that it can't be done. So I hope I've kind of just set out in terms of religious discrimination and where an employer will stand as far as business attire is concerned, and an expectation in terms of the courts, video hearings, clients, etc. It's a question that often arises. Another one that often arises is workplace places to worship. Now, obviously employers need to be fairly inclusive. Everyone decides to practice their faith in different ways, and normally an employer will see it as a good level of engagement in terms of having a place where you can worship. If there's no nearby mosque or gurdwara or temple or church, then sometimes simply having a room that's available, multi-faith room even, is very useful, and a lot of the universities have been pioneering this, which is fantastic. So normally you don't tend to have these issues, but let's take a scenario where an employer says no, they're not going to allocate a place, and you then say, well, actually I need to go out 5 times a day to go and pray. The employer again is entitled to say that if it is going to be disruptive to employment, then they're entitled to say that you can't have, for example, 5 breaks during the day, because there needs to be parity with everyone else. And again, if you're in court or you're on a building site and you're halfway through a project, you can't just suddenly up and go. So that's a common situation that occurs. But let's take a scenario where somebody says, well, I'm not going to let you go to the mosque, which is just around the corner, because nobody else gets that. Now, what you could say is, well, I'd like to go to the mosque. Instead of taking my 1-hour lunch, I'll take half an hour lunch and I'll take 15, 20 minutes to go to the mosque. An employer then may find themselves in a difficult situation if they deny your request. Now, if that request is not going to hamper your employment, then that might be a difficulty for an employer to say, well, why can't you just let them take 15 minutes off if they're going to shorten their lunch? If an employer is able to make a justifiable employment reason by saying, for example, client meetings, court, being on a construction site for certain periods of the day, then they're entitled to run their business the way that it actually operates. But again, generally having dialogue and educating your employer is a good way forward, because most employers will be accommodating, providing it's not disruptive to employment. Okay. So I've just dealt with first part of the show. It's Rafique Patel, Bond Adam Solicitors legal show on the dress code. And just a reminder, we are Ramadan, RAMADAN.FM. Listen online. It's 87.7 FM. If you want to call in, 0116 4822 086, or WhatsApp 0774 885 5055. So, Assalamu alaikum, it's Ramadan Radio and it's a legal show. So, I was talking earlier about two matters I'm going to discuss today, which is employment law and also consumer rights. So, employment law, one common issue that arises is dress code, religious discrimination, and also not having access to prayer facilities at the workplace. So I've discussed that today. What I'm going to do now is talk about how an unfair dismissal claim proceeds. So often it can be a lengthy process, but the way it starts is it starts with a letter, normally to your employer, making various allegations, then giving a reasonable time to respond. But let me tell you about time limits. Time limits are very strict in employment cases. You're expected to bring your claim within 3 months of dismissal. And if it's a discrimination claim, within 3 months of the act of discrimination, even if you're still in employment. And the reason for that is that so things are fresh in the mind and the employer can deal with matters straight away. So let's take a situation where you've been dismissed, you've gone through a procedure, you've been dismissed, you've appealed and the dismissal still stands. Then from the date of the dismissal, not the date of the appeal, you have to bring your claim for unfair dismissal. So that's generally the position regarding an unfair dismissal claim. What type of things can you complain about? So, for example, if the process was unfair, it was tainted, it was biased, your employer didn't look at things which they should have, then that's the situation as far as that's concerned. If, however, it's a discrimination act, then you've got to bring your discrimination claim within 3 months of the act of discrimination. So you've got to be very careful with that. Sometimes it's a continuing pattern of abuse or discrimination, and so it's very difficult to pinpoint when it might have occurred. But that's the situation regarding when you have to bring that action. So let's say that ACAS, which is a conciliatory service, gets involved, but they can't resolve the issue. So then what happens is you bring your claim. You bring your claim and it might take weeks or potentially months before you can get that claim issued and served on the other side. So what then happens is they get it and they have to fill in basically a response. So they put their response together, they set out the position that they see it, and the next stage is you can do a further reply, or you're then on to the tribunal filling out a questionnaire as to how to case manage the matter. So you fill in the questionnaire, you tell the tribunal how many witnesses you're likely to have. You tell the tribunal about the issues and the evidence that's needed and whether the other side are obstructive. And then a timetable is set for the exchange of documents by both parties. You then prepare witness statements. So witness statements of people who are going to help you essentially in terms of your case. So once you've done that, you're then on to a final hearing where evidence is given, and that evidence will then determine whether or not you're believed or the employer is believed. One of the large matters that's dealt with is if the employer followed a fair procedure. That's one of the big things, because the tribunal does not like to interfere with an employer's reasonable decision, providing it is reasonable, of course. But if a procedure has not been followed, for example, if you were dismissed without the facts being investigated, if you were dismissed without a procedure, without having a chance to be heard, if you were dismissed without giving you a right to appeal, then that is potentially an issue that they could find that the dismissal was unfair. Even if, for example, your conduct is fairly obvious, they can still constitute it as unfair dismissal. But what can happen is any award that would have been given to you would have then been a situation where the award will have been reduced. So, for example, if, you stealing money from an employer, they fail to follow a procedure, the tribunal could say, well, we're going to reduce your award by 100%, simply because it is likely that you would have been dismissed anyway. That's known as a Polke deduction. Okay, so let's go on now to talk about the different types of discrimination. So one is obviously race discrimination, and let's have a look at the types of examples and the test that is necessary for that. So that can exhibit itself in two ways. The most obvious way is if somebody says something to you that's derogatory, that is clearly racist, then that on its own can be enough. But commonly, that doesn't happen. People are quite filtered in what they will say, and normally discrimination happens in some kind of form. If you've been overlooked for something, you never get promoted or something like that. However, but let's take an example that there's 10 people, 9 are non-Muslim, 1's a Muslim, and the 9 are progressed and 1's never progressed. What happens there? Now, just because the Muslim has not progressed and 9 non-Muslims have progressed, does not mean it's necessarily discrimination. However, an employer has to justify on what basis 9 progressed and 1 didn't. So, for example, you would raise the issue. If, for example, somebody has made a comment that someone in the employment team or those decision makers have made some kind of comment that your face doesn't fit or some other derogatory type of comment, then it can be argued that, well, here is the nucleus of me claiming that it is racial discrimination, and it's because this is what was said. However, the employer can come back and say, well, let's have a look at the records of 10 people. If they can show that 9 people have progressed based on merit, and 1 person hasn't, and maybe that 1 person is a Muslim and 9 others aren't, that is not discrimination. So be very careful. We get many cases where this type of scenario occurs. Nothing is said. The employee says, I believe it is that. But the employer produces justifiable records of how people have progressed. So that's that. Let's take another scenario where somebody out and out says something to you that's racist. For example, called you PAKI. Obviously, that's racist, and ordinarily, on its own, if an employer said that to you, that destroys what is known as the trust and confidence in the relationship. So that's a thing that you need to note. Employment relationships are about trust and confidence. An employer is there to help you, to assist you, not to mock you when you've done something wrong. And you may have done something wrong because you have not been trained. But if someone's mocking you and is racist towards you, you can actually leave and claim unfair dismissal. Now you might say, well, how can I do that because my employer has not dismissed me. Okay, here is a concept called constructive dismissal. So if your employer makes your employment so intolerable that you cannot stay, then you can actually turn the tables and claim something called constructive dismissal. And often it does happen in these situations, such as matters of race or religious discrimination or sexual discrimination, where obviously the employer doesn't dismiss you, but that doesn't mean that your employment has not become so intolerable that you have to stay. So you would then serve notice, and you would cite that because of this level of discrimination, and you would set out the terms, my employment has become intolerable, and on that basis I'm not prepared to stay. And let's look at the situation about notice. If it's, for example, bullying by a particular individual and you have to see them every day, you might be able to argue that I'm not going to come back. I'm going to serve my notice, but I can't face this person because they've been bullying me on a periodic basis. On that basis, the situation would be that you would try to argue that the workplace has become so intolerable that you'll basically not serve your notice, and then it's for the employer to try and counter that. Obviously, if you're ill, you suffer depression or some other issue, then that might be a feature that you can look at. So that's on racial discrimination, and often it's understood that these things are done by innuendo rather than being direct. So that's a situation that can occur in terms of innuendo, in terms of discrimination. So I hope that helps. Let's look at other forms of discrimination. There's one called age discrimination, and often some elderly people sadly will not be retained in their employment because their face may not fit, or there may be issues in terms of other matters that people want a younger workforce. Well, again, on a justifiable basis, if you're doing, for example, heavy duty, heavy labor employment, and you can't turn things around on a regular basis and for your own safety, then that might be an issue in relation to that. So that's an age discrimination issue. There would be very few circumstances where an employer could argue, that age discrimination is justified. Often that's not a situation that is justified, so it's likely to be found to be discrimination. Anyway, just to recap where we are, it's Ramadan Radio 87.7 FM. That's www.ramadan.fm. So you can listen online, or you can tune in to 87.7 FM. It's Rafique Patel, the legal show. If you want to phone in, if you want to text or WhatsApp, you can text or WhatsApp on 0774 885 5055. If you want to call, 0116 482 2086. Okay, so to recap where we are, I've been asked to deal with two subjects today, which is employment law and also consumer rights. I've spent the first 20 minutes talking about employment law, just to recap where we were in terms of employment law and common issues that arise. Dress code is one very common issue that people suffer. I talked about unfair dismissal and how long a case can take. And then I spoke about discrimination, commonly racial discrimination, and age discrimination also. So that brings me on to one subject which I've been asked to talk about as well, which is consumer rights. So one of the things that often happens, especially buying off the internet now. How many times have you bought something off the internet? It's not quite right, it's not as described, but you're now in a situation where you can't be bothered really to give the item back. So in these situations, you've got to be careful on what you're buying. If you're buying something that has been tailor-made for you, then there is a risk because you won't be able to give it back. If, however, you buy something off the internet, then the distance selling regulations come into place, in that when you receive it, even if you didn't like the color or the look, then you can give it back. Now, let's look at one thing that's quite common now, in fact, on the internet, which is trading in counterfeit goods or fake goods. And given that sometimes counterfeit and fake goods are quite good replicas, sometimes difficult to identify. And so what would happen if you bought something that was counterfeit? So again, you're entitled to your money back, and you can then take the matter up with the company and something called trading standards. So a lot of the large companies, they have a lot of difficulties in terms of convincing trading standards to bring prosecutions, but especially the large companies who brand reputation is very important, is key. So for example, a number of the big brands, they rely upon their brand to make them money. And if everyone's copying their brand, then what's the point spending so much money to buy it? You might as well just buy it counterfeit. So what trading standards will do is they will go to the supplier. If the supplier can't prove where they've got the items from, or they don't have a license to manufacture them, then they can take those away. And what they'll do is they'll confiscate the items, or they'll give them back to the company. They'll probably most likely be destroyed because they're counterfeit. But they'll now bring court proceedings against the company that was manufacturing. And that's the situation. So they'll prosecute them for the profit that they would have made. Now, this is quite interesting. For example, if there's a garment from a large manufacturer which costs, say, £500 each, and this company is selling it for £100, then what do you think the loss is? The way they calculate the loss is the £400, because basically the benefit that you've got is you've got £500 worth of benefit for one item. So the way they calculate the loss is on 500 and not 100. So you can find yourself in a lot of difficulties in relation to this matter. So that's trading in fake goods. But there's another dangerous part to fake goods. Let's take talcum powder or shampoo or something like that, which has foreign labels on. Now, obviously it's cheaper. There's a lot of European supermarkets, and the law is that you have to label the item in English. So for example, if you buy a 24 pack of Coke and it's in a foreign language, the seller has to put the language in English. And that's the arrangement that has to be made. So, and you might wonder the reason why. Why is it necessary? It's a can of Coke. But for example, you might be allergic to some of the ingredients in that Coke, but you won't know because you can't understand the label. It's in foreign. So that's under the Labelling Act, that you have to label things in English. Let's look at, say, talcum powder or shampoo. Why is it dangerous to buy those items which are from a foreign manufacturer? Now, Procter and Gamble or whoever it is that manufacture these items, you might wonder whether they're actually made by Procter and Gamble, say in a different country, or are they actually counterfeit and it's just soap and water with a number of chemicals. Now, that's potentially quite dangerous. Not only is it dangerous for an adult, but that talcum powder will go onto a child. The shampoo may go into a child's eyes. And so trading standards will then prosecute and potentially criminal prosecution for those matters. So those are the situation as regards consumer rights. Let me talk to you about a cooling off period now. So the distance selling regulations introduced this cooling off period, which helped on impulse buying. So the impulse buying is that you see something on the internet, it looks good, you've checked the measurements, you get it, and you don't like the color, or the color doesn't match. You're entitled to send it back. If the company says that you've got to pay to send it back, then if it's within the cooling off period, then you don't. You should simply send it back. If you have destroyed the wrapping and various other matters, then there might be an issue in terms of you paying for the packaging, because it's got to be repackaged and that packaging may not be available any longer. For example, if it's a video or a television and you've thrown all the polystyrene away, who's now going to buy that? It's going to be a considerable loss for these companies. So I hope I've spoken about consumer rights in terms of the cooling off period. I've spoken about fake goods. I've spoken about employment law. And I'm going to recap where we were for a moment with just about 12 minutes to go. So this is Ramadan Radio. FM is 87.7. That's RAMADAN. If you want to listen online, it's simply www.ramadan. That's RAMADAN.fm. If you want to call in, it's 077 48 855 055. That's 07748 855 055. And it's Rafique Patel here from the Legal Show every week. It could be the last Legal Show, depending on how many rozas you made. Controversial issue. But I won't go into that. We may have a show next Monday, we may not. So let me just recap where we are in terms of the subjects that I spoke about today. So I was asked to speak about two subjects, employment law and consumer rights. I spoke about religious wear in the workplace. Do you have the right to demand that you should be entitled to wear religious wear? Now, as I've said, that employers need to be flexible, because if someone wants to observe their religious duties during the workplace, then why not? It attaches them more to a company. But do you have the right to demand that, for example, you should wear a jubba to work? Call in if you've got a view about this. I know some of the views that we've had is that if it doesn't hurt anybody, then why can't we just go ahead and do that? Well, the situation is you can't just do that, because it's got to be in keeping with the running of a business. For example, if we take a law firm and you're attending court, whether that's on video or whether that's in person, then it's likely that you're going to need to be in business attire. So you'll have a suit, you'll have a tie, you'll have a shirt. If you're a lady, you'll have some form of suit jacket or a blouse, and that's what you're likely to wear, because that's what's recognized. However, some religious wear may be acceptable, which is the head garment or something like that. So you've got to look at the context of your request. Equally with meeting clients, there's an expectation from those clients that you will be in business attire when you're meeting with them. But given the pandemic, many firms have in fact relaxed the dress code to say if you're smart, you're casual, what's the harm? Clients come in smart casual, so don't see any harm. Obviously, there's some people who wish to wear suits, and that is fine. But in terms of casual wear, then it very much depends upon the employer. Equally, I raised an issue that, for example, if you're a health and safety inspector, your construction site supervisor, then is it appropriate for you to want to wear a jubba on site? Now, if there's a genuine occupational requirement, then an employer is entitled to say, no, you can't, because it's dangerous. So wearing a long flowing jubba on a construction site, going up and down ladders, things getting caught, that can be a difficult issue. So on that basis, that's not an acceptable situation for an employer, nor is it for an employee. But as I've said, people tend to be fairly flexible now, so why don't you ask? We then talked about unfair dismissal and how long that takes. So I indicated that it can take anything from 6 months to 12 months to bring an unfair dismissal claim, and you must bring your claim within 3 months of the act of discrimination or the dismissible offence. It's not from appeal, it's from the dismissal date. And then we spoke about discrimination. Most common one that we come across in the Islamic sector is religious discrimination. And we talked about how often it's not something that's said, because people tend to have some kind of filter when they speak in the workplace, but it's by innuendo or sidelining somebody or not promoting somebody. And I gave the example that if there are 10 people and 9 are non-Muslim and 1 is Muslim and the 9 have progressed and 1 hasn't, just because that person is a Muslim does not mean that is discrimination. Now you might say, well, how can that be? 9 non-Muslims have progressed, 1 hasn't. That must be discrimination. Unfortunately, it's not as simple as that. If the employer is able to justify why they have promoted 9 people and why they didn't promote this 1 Muslim person, then there's nothing you can do. The employer has done it for justifiable reasons. Let's look at innuendo. Someone starts to make certain comments, and I talked about constructive dismissal, where your workplace is so intolerable that that situation arises where you can't actually stay. So what would you do then? Now what you do then is you would effectively say to your employer that I can no longer stay in the workplace because you have made my situation intolerable. So that's a situation that you find yourself in, which is called constructive dismissal, where you go to your employer and say, I can't carry on. So let's move on from that. Then we talked about age discrimination. And then while I've got 5 minutes to go, I'm just going to recap what I spoke about in terms of consumer rights and the online distance selling regulations. How many times have you bought something which, when you got it, looked very different in terms of color, in terms of texture? Well, under the distance selling regulations, you have to give it back within that short space of time, and you're entitled to a refund. Some companies are entitled to say that if you damage the packaging, then you have to pay for it. And that's a fair comment, because if, for example, you buy a TV and all the polystyrene's been thrown away, then what happens there? They can't sell it so nobody's going to buy it. They're going to have to knock it down, probably half price or something like that. And so you have to be careful with things like that. So that's the cooling off period. I just want to spend a few minutes just recapping on what was discussed in the previous weeks, because depending on when Eid is going to fall, this may be the last legal show. So we spoke about property matters, and we spoke about a number of situations where sadly people have purchased a house and, for example, planning has not been obtained for, say, a conservatory or for a porch, or there's no building regulations. What do? Still buy the house, but obviously you're going to face that issue constantly. And are you going to ask for a reduction in the price, or what are you going to do? So that's the situation regarding the property matters that we discussed. We also discussed what's a very prevalent issue now in terms of giving gifts to children to buy a house. We spoke about commercial property and trying to move tenants. Last week, we spoke about more of a sad subject, which is divorces on the increase generally now. And the pandemic has caused a lot of financial chaos in families. And sadly, a number of divorces have occurred, and they then have a knock-on effect in terms of the children and in terms of the matrimonial home, the assets and things like that. So, for example, in terms of children, the courts then have to determine who's going to look after the children on a full-time basis. And I spoke about how often it's split 5 days towards one parent and 2 days towards another for obvious reasons. So that's the situation that occurs in terms of children. Unfortunately, children often get taken up in terms of these disputes and become what's unfortunately a pawn in a game. They do get brainwashed as to toys being given to them in terms of outings, and generally the person that's more wealthier tends to try to buy their affection. So you have to be very careful about the long-term impact on children in this regard. We also spoke about family matters and the home. What happens to the home? We've had a lot of scenarios where people give gifts towards the home. Is their gift now gone? What's the situation regarding the gift? Do you get it back? Did you put things in writing that it was a gift? Did you say it was a loan? Did you have any arrangements regarding the money coming back? Excuse me. So that's a very complicated area in terms of gifts, especially from parents, from brothers and sisters. The house prices are going up, and now many family members come together to help out the couple who are buying the house. The deposits are 30%. But what happens to those gifts? Are they gifts? Are they loans? What happens, sadly, if a divorce arises? So that's a common situation. And then you've got issues of child maintenance that can occur in terms of is any maintenance due? And commonly it's a wife who will claim for maintenance, although sometimes a husband does as well. Often these situations can arise, and the courts look at the expectation in terms of income, what type of lifestyle was being enjoyed, holidays, etc. And that's quite a complex situation as well. So with 20 seconds to go, it's Rafique Patel finishing off from Bond Adam Solicitors on the legal show. And thank you all for listening to today's show in terms of employment law and consumer law, having covered various